Thanks for coming to the session, How Litigation Experience in the Courtroom Can Enhance Your Mediator Skill Set. If you have any questions, please put them in the chat and we'll address them at the end if there's time. So in this image you're seeing, my favorite courtroom in the whole world. It belongs to the Chief Judge of the U.S. District Court for the Eastern District of Michigan. If you're not familiar with it, I urge you to go visit the courthouse, have a look. It's inspiring. As a young lawyer, I tried several cases in that courtroom, loved every minute of it. So I also loved attending ICLE's annual Trial Advocacy Institute they held at Hill Auditorium every year. It was an opportunity to learn from the best trial lawyers in the country, watching them try a case live on stage. The head of it all was the great John Reed. He was then dean of the University of Michigan Law School and a great trial advocacy teacher himself. John once said something that stuck with me ever since. He said, "You can't teach an old dog new tricks, but there are some tricks only an old dog knows." Without noticing, the young trial lawyer sitting in that audience 50 plus years ago now finds himself an old dog with a few of those old tricks. And my aim today is to share them with you. For starters, however, let's use a mediator technique. Let's reframe. We won't call them tricks. We'll call them lessons learned from the courthouse college. You wouldn't normally think lessons from the courtroom would readily translate into an approach to mediation or a mediator's intervention, but you'd be wrong. Let me first disclose a true fact. I'm now retired. I have not taken a new matter in 2 years. This image was taken in Cornwall, England, hiking the summer with my wife along the coastal path. That's my new life. So my hope is you'll find a nugget or two you can incorporate into your own practice, that these things I'm going to talk about are not too out of date. As my father liked to say, any damn fool can learn from his own mistakes. The wise learn from the mistakes of others. So here goes with my first lesson. Dressing thoughtfully is a rational approach to managing first impressions. And as Will Rogers taught us, you don't get a second chance to make a first impression. The issue is whether you want to manage that first impression or not. And I suggest you do. In trial, I wanted the jury's first impression to be that I was a serious, competent, credible, and professional trial lawyer. Not slick, not fancy, the right guy for the job. And doesn't the same apply to being mediator? 50 plus years ago, the country was enthralled with the Nixon Watergate hearings on TV. Every one of those witnesses wanted to be believed. And all the commentators at the time said, it's navy blue suits, with or without pinstripes. That's what projected sincerity and trustworthiness. And ever after, my suit on the first day of trial has always been navy blue, and the first day of mediation and the first day of a presentation. So let me share one more specific technique with you that I developed involving neckties. And let me stop sharing my screen for a minute. So here's my tie. So I specialized in handling, Tribe, can you make my image larger? Well, I specialized in employment discrimination claims on the plaintiff side. And one of the principal defenses then, as now, was to place every individual piece of evidence of discrimination that I presented under a microscope to argue that upon close examination, that piece of evidence in and of itself didn't show anything, and certainly not discrimination. And after reducing each piece of evidence to zero, the argument then was the claim must fail. So anticipating that, because you heard it all the time, when closing argument came, I always wore the most complicated necktie in my closet. And when management counsel made the expected argument, I'd rebut with my necktie. You see this pattern, I would say, if you pull out just one thread, any thread, and place it under a microscope, all you're going to see is like a black line or a hair. And the same with thread 2, and the same with thread 3, and so on. No pattern. But put them all together and taken as a whole, you get something entirely different. Um, and that's what the defense did here. They examined each piece of evidence on its own. They put it under a microscope one at a time, and you never saw the pattern. But I suggest if you weave each individual thread together, the pattern of discrimination is pretty obvious. I had a lot of success with that argument in trial, at case evaluation, and during mediation. And now, when mediating employment cases where it appeared that this technique was being employed by the defense, I'd wear that same necktie. Visual aid, if and when it might do the most good as an intervention to underscore a significant risk. The principle applies whether you are partial to neckties or to dresses or whatever suits you. So with that, let me go back to screen sharing. And my next slide, setting a tone of professionalism and integrity, understanding that everybody is always watching. George Bedrosian was a mentor of mine, and he taught me that what you wear and how you wear it signals many things which impact the impression we make on juries. That includes your jewelry, your wristwatch. He never wanted anyone to think he was wearing a Rolex. Your rings, if any, and even the fountain pen you use if you keep your notes that way. Equally important, George recognized we're being observed by jurors every minute and in every setting, including spaces outside the courtroom, in the elevator, in the restroom, in the parking lot, in a restaurant at lunch, or wherever you are during the process. And what they see when they think you don't know they're watching is what they're going to rely on to determine who they think you really are and whether they can trust you. I never forgot that lesson either, and it applies equally in regard to live in-person mediations. So mind your language. Words matter. Trying cases in front of juries made me conscious of word choices. For example, I've been known sometimes to drop the F-bomb for emphasis. Not a good idea in front of a judge or jury, and probably not in front of the parties or the lawyers when you're in the mediator's chair. In ICLE's 40-hour hands-on basic mediation training, I've observed many registrants who don't think much about their language, and it doesn't come across as particularly professional. Uh, People often use the phrase to a joint session, you guys. Okay, if you're comfortable with that, maybe. To me, it's too breezy, too casual, seems a little unprofessional. Watch it. And language choices around technical terms is very important. Are the parties actually following when you're talking about ADA, FMLA, FLSA, and so on? You can certainly use letters or acronyms, but make sure the parties are following along. So next, connecting and building relationships. Jury selection is all about making connections, gaining trust, and building a relationship with each person seated in the jury box. That's done through several factors, but a particularly important one is eye contact. The lawyers typically pick you to mediate because they trust you already. They want their clients to do so as well. But you still need to build that relationship. You want everyone in that mediation room to feel respected, acknowledged, recognized, and important, and that requires eye contact. I was taught as a young trial lawyer, make contact with every juror and do it often, not just during jury selection, not just during opening statement or closing argument, but during direct and cross as well. Look over at them from time to time, make a connection, see if they're watching. Did they get the point I just made with this witness? Did they understand what the witness just conceded? The same with answers to questions during mediation. When you're interacting with a party, is the lawyer paying attention as to what's coming out? Did the party just hear what the lawyer just conceded? Did they get it? So you want to keep building those relationships, and eye contact is a key part of that. Getting the names right. Everyone has a name, and in a trial, we had a name, a jury list with everybody's name on it. And though it might be easier to say, so, juror number 7, have you ever had a bad experience with a police officer? Way better to say, Ms. Brown, have you ever had a bad experience with a police officer? Getting the names right shows that you care. It shows you value the listener sufficiently to learn their name and how to pronounce it properly. So at the beginning of every mediation, I ask, how do you prefer to be addressed? What's your preference? Do you prefer first names or last? And then I live up to that commitment. And by the way, if someone in the room has a title like doctor, I think of that as creating a power imbalance in the room. So I refer to everybody as Ms., Mr., or Mrs. in such circumstance. Okay, finding your own voice. Being yourself, being genuine, performing as yourself is a critical element of gaining trust and building a relationship in a courtroom. Every trial advocacy program I ever attended emphasized the importance of being comfortable in your own skin and your own performance. And I think the same applies equally in mediation. No matter how much you may have admired this or that mediator whom you've observed or worked with, trying to channel that person when you're in the mediator chair, it's not going to go well. People can sense it's forced and artificial. So you need to adopt language and style and technique and interventions that suit you and your approach that works for you, that you're comfortable adopting. However, if there is a technique you learn from an individual, you might think about introducing it as something you borrowed and give attribution. For example, in getting acquainted with a party in mediation, I often encounter skepticism about the process and my role, what I'm going to be doing as mediator. And when you explore that skepticism, you discover plaintiffs often expect that you're going to push them to take less money than their case is worth, and defendants expect to be pressured to pay more money than the case is worth. Well, I like to address that issue head on. So here's what I'd say. Look, this is your case and your money and your decision. Forcing you to take more or pay less, pay more, take less, that's not my job. My job is to make certain you have all the information available so that you can make a good business judgment about whether to settle and on what terms. And I reinforce that message with an approach I picked up from an advanced mediator training we did when Lee J. Berman came to Michigan a few years ago. It has some humor and it's edgy. And so I've never really felt comfortable just stealing it whole hog. So here's how I did it. I want to assure you, I'd say, I'm committed wholeheartedly to the principle that whether you settle and on what terms, that's entirely up to you. No question. This is your case, it's your money, it's your business, it's your decision. My job is to get you all the information you need to make a good business judgment and whether it's in your best interest to settle or not. Your call. And to underscore this point, I want to share something I learned from a great California mediator named Lee J. Berman. Lee J. puts it in terms of good news and bad news, a good news, bad news story. The good news, he tells people, is that I've mediated over 5,000 cases in my career. The bad news is I haven't settled a single one. And as the jaw drops and they try to figure out how to react, I say, that's because I don't settle them. you do that always gets a laugh and a nod, and it gets the message across, and it's attribution to the source. It tells them they can trust me and to help them make a good judgment. I'm not going to force anyone to pay more or take less. That's up to me, not up to me. That's up to them. Okay, moving along. You're a teacher, so teach. Most people have a favorite teacher that they love. And as a trial lawyer, I took advantage of that experience. A teacher was someone who helps people learn, someone who enlightens them, someone who inspired them, someone in whom they had confidence and placed their trust. So, channeling a favorite teacher is easy in mediation. You're teaching all the time. When you're hired, you educate the lawyers as to your unique approach to mediating. You help them prepare and you provide tips on how to make the most of the process. You also educate the parties throughout. I have a website, for example, with a ton of study guides and informative articles and advice for parties and lawyers with my suggestions how to make the most of mediation. Even though I'm retired, I keep that website up. I encourage you to take a look, www.starkmediator.com. You're welcome to link to anything you find there under articles and links. I ask only that you give attribution. For example, I have a paper designed primarily for parties I call Negotiation 101, what to expect in the negotiation process during mediation. Another, how to make a presentation to the decision makers on the other side, how to write an effective mediation summary. And so when you model good teacher behavior, you're the beneficiary of all those great education experiences almost everyone has had. We call that the halo effect. They attribute their respect and admiration for that teacher to you. It's a great bet and too often underappreciated by new mediators. Teaching adds value to the process and assists everyone in making better and more informed decisions. The cases settle and you're remembered the next time they need a mediator. That builds your book of business. And because a picture is often worth 1,000 words, I have an extensive deck of PowerPoint slides I carry to every mediation on my iPad to illustrate points or underscore advice. That's also understanding the power of teaching. Some people are visual learners. Visual aids endear you to people who learn better from seeing more than from hearing. Remember that. And the screen sharing feature of Zoom makes the use of images even more convenient and easy to do. So the next time you're sitting in the mediator chair, consider how you might channel your favorite teacher and thereby enhance your credibility, gain party and lawyer trust, and build a stronger relationship. And along that same line, use understandable language and teach, explain jargon and legal concepts. As a trial lawyer, I handled mostly personal injury cases, employment and wrongful discharge matters, and police misconduct litigation. That often meant the use of expert witnesses, doctors, therapists, accident reconstruction experts, economic damage modelers, engineers, and experts use jargon, and some of them can't help themselves even when the jargon gets in their way. So I learned always to make a point of explaining the jargon to the parties at the mediation table, just as I tried to do with juries. This is especially true in mediation with legal concepts. The most common and maybe the most important example in my practice is when summary judgment is discussed, which typically comes up when discussing risk factors. Why? Because in many disputes, including almost every employment case, there is a risk that the assigned judge might summarily throw that case out of court without a trial. So identifying the judge was almost always an important topic for discussion. And that judge's track record or orientation was particularly important. But here was my observation. For the most part, during these discussions, the client's sitting there without a clue. So I'd ask them, are you following what's going on here? And generally the answer was no. And so here's what I would say. Look, Judges have the power and the authority to determine whether a case warrants trial by jury. In almost every employment case, whether truly warranted or not, the defendant, the employer, is going to take the opportunity to tell the judge that this is one of those cases that doesn't measure up. We call that a motion for summary judgment. In other words, the judge can enter judgment summarily and without a trial. And suddenly, if that's granted, your case is gone. It's dismissed. You're out in the cold. And suddenly, the next decision you have to make is whether you want to spend the money on an appeal. Many judges take summary judgment very seriously, and some are more likely to dismiss a case than others. We all keep track of these things, and we know which judges do it and which ones are reluctant to do it. The defense in this case is either filed or is threatening to file a motion, and your lawyer is concerned about it. And you know what? This is nothing to scoff at. These motions are granted more often than not. What we're talking about here is how this might impact your case. Are you actually going to be given the opportunity to present your evidence to a jury, or will you be locked out of the courthouse? Suddenly, we have their attention. Now, some plaintiffs blow it off, and that's chalked up to you can lead a horse to water, you can't make him drink, but others want to know more. So I might ask the lawyer, would you call this judge plaintiff-oriented or defendant-oriented? Has the judge ever decided a case like this one before? How has he decided it? How would you assess the likelihood of dismissal? What's the percentage likelihood? In my experience, plaintiff lawyers often say, well, 50-50. Well, did you hear your lawyer say 50-50? Uh, what do you think about that? Is that something you want to do? If you were in Vegas, would you bet thousands of dollars on a 50-50 proposition, the red or the black at the roulette table, for example? Surely, if there's a substantial settlement offer on the table, even if it's not what you want, isn't that a better business judgment than to roll that 50-50 dice? Now, of course, if the judge is liberal and known to reject summary judgment, you have a parallel conversation in the other room with the defense. So you also should be thinking of yourself as an expert witness and maybe the most important witness of all. And here's what I mean there. Again, years ago, I attended a seminar where Jerry Spence was the speaker, and he said the most important witness in any trial is the trial lawyer, him or herself. And that's because the trial lawyer's credibility is on the line. Trial lawyers need to be trusted and respected, especially when she discusses who the witnesses are and what they're going to testify to and what the evidence shows and the conclusions to be drawn and the attacks that are made on adverse witnesses. So, to the mediator, an informed neutral, someone paid to provide the parties with the information available for them to make good judgments, someone expert in the process of mediation, if not the subject matter of the dispute, someone to turn to for direction, counsel, and explanation, someone who genuinely wants to help you face the risks realistically and measure the magnitude of those risks objectively. You can do this because they trust you to help them get it right because you've been helping them all along. Now, believe in your process. I was a great believer in the ability of jurors to make right choices about whether to award my client their verdict. In all the jury cases I ever tried, I can think of only one case where I thought the jury totally made a botch of things. I believed in the jury system, still do, and I made certain the jurors knew I had every confidence in them. I said it explicitly in opening, and I said it explicitly in closing. I read the book Democracy in America by Alexis de Tocqueville years ago. He believed the American jury was the backbone of our democratic system, a free school in the lessons of democracy, where the conduct of the parties is weighed and assessed against community standards. Their job to determine whether the actions before them measured up. I have equal confidence in mediation. When I represented clients, I saw mediation as a great process for learning and testing the plausibility of claims and defenses, for weighing the risks, examining the costs, and determining whether to settle and on what terms. We should all believe in our mediation process. It works. It gets even the most intractable disputes resolved. So you need to have confidence in your process, and you need to convey that to everyone, even in the most stubborn disputes, because that show of confidence gives them confidence in you and in your process. It fosters optimism. It calms consternation and impatience. It keeps people at the table even when they're growing weary or frustrated, and it helps them maintain perspective, recognizing that there is still hope for a resolution. Now, mediators need to have a strategic plan. In jury trials, they don't just unfold, they are carefully planned strategically by each trial lawyer on each side. What witnesses am I going to call, and what order am I going to call them in? How do I humanize each witness and so that they'll be most credible and persuasive? How long should they be on the stand? What do I hope to get from their testimony? What are their vulnerabilities, and how might the other side use them against me? What documents do I want to admit, and through which witness? What blow-ups and visual aids should I create? Am I going to present the story chronologically or some other fashion? Might I start with the injuries, for example, and work backwards? What do I say in opening to get them ready to hear the evidence? Well, planning strategically is equally important for mediation. You need a plan tailored to each dispute you're mediating, and that takes thoughtful, serious concentration and study. I think many of you have probably heard my lecture on strategic mediator planning. You'll find my paper describing how to do that on my website. But briefly, here's what I went about doing to develop that strategic plan. I read the written submissions and attachments carefully and thoroughly. I had at least one conference call with both lawyers together. I had at least one ex parte confidential communication with each lawyer separately a few days before the mediation, after I'd read their summaries. I learned what the lawyers were worried about. I knew if they wanted help with their clients. I gave them tips for getting ready, such as gathering their fee and cost records so they'd have them at the table. And I identified the key risks from their papers. Plus, I created a timeline neutrally with all the important dates laid out so I could always keep the sequence straight as new facts came in through the process. And armed with all that information, here's how I proceeded. I'd get acquainted with the parties, asking them to tell me about themselves. I'd take their measure as witnesses and decision makers. With corporate parties, I'd learn how decisions are made and by whom. I'd learn what their goals and objectives are. And then I'd have a list of risk and cost questions to explore. And I figured out what order I wanted to ask them in, which were best to be asked in a joint session, which best in caucus. And I had ideas about how we might measure the weight to be given to each of those risks. And of course, the more I learned from the parties and lawyers, the more I'd modify and adjust the plan by adding fresh risk questions to my papers. That said, Tracy Allen taught me, blessed are the flexible, for they shall never be bent out of shape. You must be in the moment, you must listen carefully, and be ready to adjust your plan as fresh information and new insights come out. Keep your cool. If a dispute is worth sending to mediation, it's undoubtedly going to mean a great deal to the parties and their lawyers. Participants arrive with strong emotions. They're often frustrated by the dispute, and they've taken offense at the tactics of the other side. They grow impatient, they escalate, they don't really want to listen. They much prefer to tell their own story. Hence, the negotiation can be difficult, slow, and aggravating, especially with parties who are unfamiliar with the pace of how a mediation goes. As I said, I've got an article on that on my website. Now, a jury is an adversarial process. It's a battle between two sides offering damaging evidence against the other. And good evidence hurts. Hearing it is painful. Some of it may even be true. And the jury is watching how the trial lawyers are reacting. Do they see the blow land? Are they nonchalant? Are you cool as a cucumber, or does it look like you've just been punched in the gut? Same thing in mediation. You might be feeling exasperated. You might be growing impatient. You might be thinking the disputants are not making sense. But you're a neutral. You're the adult in the room. You're modeling good behavior. Remain calm. Remain in control of yourself and the process. Two techniques quickly. When the lawyer nonetheless starts escalating, even after having promised to be a joint problem solver, I listen, I let them say what they've got to say, the emotions are pouring out, and then I would say, wow, do I love your passion. I really respect lawyers who believe in their clients. And that puts that where it needs to be, out of the way and not obstructing. And if, on the other hand, it's the client who's escalating, again, listen carefully, listen fully, listen calmly, and when finished, reframe to show you've heard and understand. So you be the calm one. And that said, be a good listener. So I really have to say a lot more here. As a trial lawyer, you know how important it is how to put your case into evidence. Equally important to learn what the other side is saying. So same is true of mediation. You're listening a ton. It's especially important to listen to the clients. And the reason is the submissions that you've read were prepared by the lawyers. The lawyers, my experience, don't always clear their summaries with the parties. So the facts in the summaries can often be wrong. And lots of lawyers, even good advocates, have never had a hard conversation with their client about what they want from the process. And what the parties want may be totally unrealistic or commonly out of sync with the approach taken by the lawyers. And many lawyers use the same approach to their mediation summaries as they do to dispositive motions. And instead of making reasonable concessions and thinking about who's the right audience, party on the other side, they race full speed ahead, overspinning, overselling, leaving out damaging information, etc. So you might be left with a false or misleading impression from the summary. Um, so knowing what the real facts are, having learned it from the parties, you're able to ask better risk questions. The facts control the risks, and the risks and their magnitude are a crucial part of mediation. As Norm Tucker likes to say, nothing causes movement more than anxiety. So now let's talk about negotiations and being the negotiation coach. In my paper on reframing the role of mediators on my website, there's a whole segment on negotiation coaching. As a trial lawyer, I had great mentors who coached me all along the way. Uh, I had friends and partners who were great at coaching. So give back. As a mediator, you should be the coach to the lawyers. A major complaint I actually hear all the time about mediators is they merely carry numbers back and forth without adding value. I agree. I think our job requires more. I believe we can add real value by serving as a negotiation coach. First, we're the only ones who will spend substantial time in both rooms. And when we do so, we learn often what's driving the dispute and what might be persuasive. We're taking everyone's temperature to better understand the emotional dynamics, and we're developing a sense of what might be needed to achieve resolution. Plus, as trial lawyers, we've had a ton of experience of our own as negotiators, and we can often give good suggestions to make on how to package or present a proposal in the most attractive way. And third, much to my surprise, many good lawyers have forgotten how to negotiate. So I begin by asking permission. Would you mind if I offer a couple suggestions to assist in the negotiation process? Typically, they say yes. And if they do, I say, look, I'm never going to know the case as well as you do. So don't be afraid to disagree with me or reject my advice. And then I point out I'm the only person who's been in both rooms. And although you've been living with this case a long time, um, I might have something useful here, but it's not going to hurt my feelings if you don't find my thoughts useful. And then I go through it. If there's a dollar figure, uh, I say, this is a message. Any offer is a message. What do you think the message is that you're sending here? How do you think they're going to react? And how are they going to respond? And is that the response you're going to want? So pushing back, always valuable in the mediation. And finally, I ask, how did you arrive at this number? And my experience is that putting forth a number wrapped in a reasoned rationale is always better than what my gut tells me. Paul Monacotti taught me if it's my gut versus your gut, you're not going to get very far. So here are the assumptions. Here's what they assume about back pay. Here's what they assume about future lost wages. Here's how they came up with a number for emotional distress. And here's what their records show about attorney fees and costs. And they assess the chances of prevailing at X. Put it all together, you can now have a robust conversation about assumptions rather than an unproductive one about what's the best value for the case. Making important points. Oops. Making important points. In a jury trial, I always tried to be very conscious of the jury's attention span. Jurors may not out from time to time about some crisis at home or at work. Let me make sure I'm in the right place here. They might be thinking about some crisis at home or at work. I learned that when there was especially important testimony, it's helpful to telegraph that fact to the jury. For example, my next question might be the most important one of all in regard to X. Or let me now turn to the key issue in this case. Or let's call your attention to the meeting where you were terminated. Things are not much different in the mediation room. If a topic you want to cover is especially important, you should telegraph it. It gets their attention. It tells them you're turning to something especially important. So that's where you go. Now, getting their heads nodding. When I was a trial lawyer, my goal was with my opening and closing arguments was to get the jurors to start nodding their heads. And to encourage them to do that, I'd start nodding my head. I was once in trial before Judge Bill Giovanni. He actually ordered me to stop. He said, it's unfair to the other side. Okay. Uh, but the same is true for me in mediation. When discussing issues with the parties and lawyers, I want their heads nodding. I want to build momentum and what they're hearing is gospel, the truth, insightful and helpful. And I did that by wrapping what I said in truisms and sage advice. You may have noticed I like quoting people. So I might say, Judge David Lawson likes to say, a good settlement is always better than a good case. That's because you can always lose a good case. Bill Sankbeil, one of Michigan's great trial lawyers, liked to say, I've never seen a case I couldn't lose. Here's something else. I don't know who I got it from, but I liked it. I'd say mediation is not a justice process. It's not a process to determine who's telling the truth and who's not. Mediation is simply a dispute resolution process. In mediation, we're looking for an off-ramp to the dispute. If your goal is justice, mediation isn't going to provide that. But if you want a solution and an opportunity to put this chapter behind you and close the door on that and end the roller coaster ride, then mediation is exactly what you need. Make use of visual aids. I don't want to say a whole lot about this. I know I'm running out of time here, but I repeat, I brought a picture's worth 1,000 words. I had a whole series of images that I used in mediation that I brought on my iPad and I now use with sharing screen on Zoom to illustrate a point. And um, help somebody who's a visual learner. In addition, I always had a whiteboard, and so late in the case, if somebody's getting impatient or frustrated, on that whiteboard, I'd write down offer, counteroffer, next offer, counteroffer, next offer, counteroffer, in an effort to show that we're making progress, in an effort to show who's making the most concessions, and in an effort to help people actually get some confidence that a settlement is maybe on the horizon. Next, tell the truth. Let me flesh this point out a bit by pointing out what doesn't work as a mediator. Emphasizing an argument or a point you don't really believe in. Claiming to know the outcome when you surely don't. Asserting you know the state of the law at some point when it's outside your area of expertise. You lose credibility as a mediator, and they can smell it when you're not being totally honest. So the most important pointer here in this item is every case holds its truth. Find those truths in the mediation and help build a plausible story with those truths to tell the other side. Every experienced trial lawyer knows how to make the most of every tidbit at trial, and the same works for mediation. That's really crucial. Now, agent of reality, assessor of risks. It shouldn't be a surprise that by the time the dispute reaches mediation, the trial lawyers and their clients have fallen in love with their claims and their defenses. And what do we know about love? We know that love is blind, and blind love means sweeping all the shortcomings and warts under the rug. I actually say this at mediation. My job is to make certain everyone recognizes their risks and weighs them as realistically as possible. I'm not taking sides. I'm not saying who's going to win or who's going to lose. And if you think I'm shaking the tree here, I promise you I'm doing the same in the other room. So let's start by examining some of the risks presented by your case. I learned how to recognize those risks in the courtroom. The courtroom is a college for learning for mediators. So in my paper, I know what your job is. There's a lengthy section detailing an approach to asking risk questions. And again, I commend it to you. Persuasion and advocacy. At the beginning of a case, when we're engaged in process design, I get permission from the lawyers to start the process in a facilitative mode and become more evaluative at the end. And sure enough, after I've heard everybody out, everybody has had their chance to say what they have to say. All of my questions have been answered. I then say, can I share with you what my thinking is? This is in the interest of getting to closure. And if I've done my job right, I've been symmetrical, I've gained their trust, it's helpful. And here's what I say. This is a discrimination case. All of your evidence is circumstantial. You may win and you may lose. You never know what a jury is going to do. A good settlement is always better than a good case because you can lose a good case. So you have an excellent lawyer. Your lawyer is experienced in the process. She took your case because she believed in it, but you could still lose it. I can see lots of ways for the jury to conclude that even if there was discrimination and bias, there was plenty of good reason for discharge. You're rolling the dice. That's your right. Only you can decide this. But if you'd like some advice from someone neutral, I would say reasonable minds can differ. I would say maybe it's time to put an end to this dispute and get on with your life. A settlement provides closure. A settlement can put some real money in your pocket so you can move forward. It's up to you whether to take the risk and roll the dice or not. To me, finding a resolution is only prudent. You decide. And with that, thank you. So, oops, do we have any questions in the chat, Marianne?
Yes, we have one. Do you forewarn the attorney you are going to put them on the spot regarding judge's history?
I might. It depends on the case. So I always, after I've read the mediation summaries, and all of the exhibits, I call each of the lawyers on an ex parte basis, promise them confidentiality of our conversation. And if I think the identity of the judge is an important issue, I will let them know in advance. For instance, I'll ask them, has a judge decided a case like this before? Uh, if you don't know, I suggest in the next couple of days you research that so we can discuss it and have a good, robust conversation about it when we get to the mediation table. Anything else?
I don't see any other questions.
Well, okay. I think we're just about done. Any questions from the audience verbally? Well, then I've done my job. Thank you, everybody. Thanks for watching.